Today we're talking about using an office supply store lease or an attorney-prepared lease. Which one is better? Now, many landlords, even property managers, use standardized leases sold at the local office supply store or provided by their local Realtor Association. These are a cheap, often free way to get a lease for your rental property. But we have found they do not provide adequate protection for landlords. In fact, most of them are pro-tenant. This is what we think of office supply leases. Rubbish. So what are the differences between a pro-tenant and a pro-landlord lease? Is one more unfair to one party than the other? Well, it depends on how you look at it. From a property manager and landlord perspective, the landlord takes a lot of risk on when renting out the property. And therefore, we try to protect them as much as possible while being fair to the tenant at the same time. Our leases are prepared individually by a landlord attorney who regularly updates their leases based on current Florida landlord-tenant laws. There are several protections in a pro-landlord lease, starting off with the following clauses. 1. The late fee clause. Most late fees are not included in a standard lease as additional rent. So, our attorney includes those, and therefore, late fees are much easier to collect as they are considered rent. The risk of loss clause. If a pipe bursts, or say a contractor performs some poor work, then most leases do not adequately protect the landlord or the agent against claims due to any damages due to those causes. Our attorney includes a clause in the lease to limit that liability and then recommend that the tenant obtain renter's insurance to cover any such instances. Renter's insurance is always useful for the tenant because it also covers things like burglary, fire, and other things like that in most cases. The maintenance clause. This should be a very important clause in your lease agreements. We want to make sure that every property is well maintained, up to code and move-in ready. But you need to have a clause in your lease that prevents frivolous claims every time there is a light bulb out, a smoke alarm battery that needs replacing, or say an AC filter that needs changing. Also, if the tenant blocks a toilet, you need to make sure the tenant is responsible for that cost. The vacating and renewal clause. Make sure your lease dictates what the tenant needs to do at the end of the lease. Now, our company requires a 60-day notice in order to renew the lease agreement. Plus, we send out a notice around the 75-day mark prior to the expiration of the lease, which gives the tenant some options. So we offer them a renewal rate based on the current market rate, and our company policy is not to do a month-to-month option. So the rate actually doubles if they want to stay month-to-month. Or they could opt to non-renew the lease. And if that's the case, we'll start showing the property a few weeks before the expiration of the lease. If the tenant intends to move, we supply a tenant handbook before they move in, which has a list of move-out instructions, and that helps the tenant hand the property back in good condition so that they can get their security deposit back in full after they move out. If they don't follow that list, and we have to do those items for them, we put a claim against their deposit. And we'll discuss the security deposit claim process in another video. The right of entry clause. Most standard leases require that the landlord give notice to the tenant in order to make repairs. Sometimes that notice is written as 24 hours in standardized leases. But in Florida, the minimum legally required notice is only 12 hours. So make sure you have the minimum notice listed on your lease agreement, and that you can access the property for other things, such as showings for re-rental, sale, appraisals, and inspections, etc. You don't want to bother your tenant by popping in for an inspection every other month, but you do want to make sure that you are allowed access whenever needed. The mold addendum. Our attorney feels that it is necessary to include a mold addendum in the lease. And living in a climate that mold can form easily, such as Florida or another humid climate, it's a good idea. This outlines to the tenants easy ways to help prevent mold, such as keeping the air conditioning system running at a certain temperature, which helps to dehumidify the air. They can also check for leaks. They can use exhaust fans in bathrooms and use household cleaners such as Lysol or bleach to clean cork and tile in bathrooms. This addendum also says that if a health hazard is suspected, then the landlord has the option of breaking the lease. There are many other addenda you can use for your lease agreements, including ones for pets, drugs and crime, boats, ongoing construction, and many more. If you're worried about a specific issue with your rental properties, please contact us so we can find an answer to your questions. You can reach us on the web at www.wemanageorlando.com.